What's been thrown out by the federal judge, what's still in effect, and what's next in our fight to shut down Kathy Hochul in federal court.
So our team spent literally hundreds of hours. We devoted more time to this than almost anything else because we had to get this right.
Hi guys, Aaron Dorr here at the New York State Firearms Association, and we are being hammered with questions from our members, other gun owners, politicians, reporters, everyone asking us for an update. Where do things stand right now today in the fight to shut down Hochul's law in federal court? So we're going to answer as many questions as we can in this one video, but I want to draw your attention to a big caution. Number one, we're not lawyers, but more importantly, number two, situation is changing right now by the day, sometimes by the hour. So what's true in today's broadcast might not be the same a couple of days from now. So use extreme caution when trying to decide where and how you carry a firearm here in New York State. So everyone knows, I think, how we got here. Right. We had the Bruen decision from the Supreme Court in June, went right to the heart of New York State's unconstitutional permit system, and it struck out the requirement for a justifiable need provision in that permit. So no longer are we required to surrender to the government a justifiable need. Shockingly, as American citizens, we have the right to keep and bear arms, and that includes concealed firearms, whether or not Hochul thinks we have a need. That's what SCOTUS said in June. They also said in that decision that the right to carry does not just mean on our own property, that we have the right to carry a firearm for self-defense out in public, in places that we're lawfully allowed to be, unless they're sensitive locations. What was obviously meant, if you read the Bruen decision by that, was places like courthouses, jails, places that you obviously cannot carry a firearm. Of course, what Kathy Hochul did then in reaction to this was madness. Now, what we've seen in lots of blue states is they've already begun to unwind their bullcrap gun control laws to comply with Bruen. Hochul, she's a demented, aging tyrant, and she went the opposite direction as far as she possibly could. So right now, where things stand today, the federal judge has issued a temporary restraining order which blocks New York State from enforcing key provisions of what we're calling Hochul's law in today's video. He did not block all of it. He did not throw all of it out. He threw part of it out. He upheld portions of it, and he modified portions. We're going to go through and break all this down for you. But before I do that, so he issued the temporary order, and then he put a delay on his own order for a couple of days. It's now in effect. And in this interim time, the AG, Tish James, has filed her own papers appealing this block with the Second Circuit Court of Appeals, asking the federal court, higher up federal court, to strike down this temporary order. So I know it's confusing. We have a temporary block in place. The state hates that, no surprise, and they've all appealed to the Second Circuit asking them to weigh in on this. That's where we are right now on the legal positioning. But again, the question you have is, where the hell can I carry, and how can I apply for a permit here in New York? So I'm going to address the permit application process first, then we'll break down what the judge's order did when it comes to gun-free zones. So again, Bruen says no need to show a justifiable need when applying for a permit. It could have been left just like that. Hochul went the opposite direction. So what she did in Hochul's law was require an in-person interview as part of your application process. That has been removed by the federal judge. Hochul also said that if you apply for a pistol permit, you have to give your information, of course, but also your spouse's information, any previous domestic partner's information, any other adults who reside in your house, their personal information, your adult kids, anybody who's in your home as an adult, all of their information gets wrapped into your pistol permit application. That's been removed by the federal judge. The judge also, in a major smack, struck down Hochul's provision that requires we surrender all of our social media accounts to the government as a condition of our permit application process. So again, that's also been removed. So you're not going to have government agents eyeballing your Instagram account, your Facebook page, or all of your social media as a condition or as part of the permit application. What the judge upheld was, for the most part, existing law. There is still a need to show that you have training. There is still a need to show 4 character references. And just to be clear, that's all BS too. Don't get me wrong. None of this should be the law right now. I'm just saying that was the law that's still in effect even after the judge struck down the rest of the provisions I mentioned a minute ago. So still have to have references, 4 of them. So to show training. And in a very bad decision, he also allowed the following phrase to remain in effect: any other information that is reasonably necessary and related to the review of your permit application. Now, in a red county, I mean, Ontario County, Penn County, most of the southern tier, Western New York, that's not going to be a problem. They're not going to ask for anything else. But if you're in one of the cities, if you're in a blue county, if you're anywhere downstate, that is wide open for abuse, and it will be abused. That was a very ominous provision to leave in Hochul's law. But that's where we are on the application side. What about the sensitive places? Again, SCOTUS said in Bruin that you can, unless it's a sensitive place, you can carry there in the public arena. Well, that's exactly the problem. Hochul's law deems the whole frickin' state a sensitive place. The judge was not amused. The following places were off limits. They're now on limits to gun owners here in New York. Libraries, public playgrounds, parks, and zoos. Those are back to being places we can carry in. Childcare providing locations, childcare program facilities, locations that provide behavioral health services, summer camps, locations of programs that are state funded that deal with developmental disabilities, addiction services, mental health, disability services. Those are all back on limits for us to carry in. Homeless shelters, family shelters, etc. Public transport systems, trains, cars, subway cars, buses, ferries, railroads. These are all areas that are now, again, back on limits for us to carry in. Restaurants, that's a huge one. And any place used for sporting events, art, entertainment, or gaming. So these were all off limits pursuant to Hochul's law, and they're now on limits, again, because the judge has blocked that enforcement. That's the area where he sided on our side. The following areas, though, remain off limits to gun owners under Hochul's law. And some of these were already off limits. Some are added in the law that was passed in August. All property that deals with education, so all educational facilities are off limits. Of course, that makes perfect sense, right? Most mass shootings happen in schools, so naturally we're going to disarm parents, and teachers, and janitors, and everybody else who has a chance to defend our kids. It's madness, but that is still law. Any location being used as a polling place, you cannot carry when you're going to vote. How democratic of us. What a joke. Any public sidewalk or public area restricted from general public use with a limited or special use event permit in place. So if you have a certain event, a protest, for example, on a public road or a public street, you have a special use permit to do that. You cannot carry there. Any property owned by the federal, state, or local government, you cannot carry there. Much of that was already the case. And you can also still not carry in nursery schools or preschools. Those areas all survived the injunction that was issued by the federal court judge. Now, the big one you're all asking us about is, what about the blanket ban? What about the blanket ban on all retail or commercial businesses where you can't carry unless those businesses put up a sign that says you can carry in our business? What about that? It's been struck down with a modification. So the judge struck that section down. It is gone, except when it comes to churches. Because again, other than schools, churches are the most often attacked area by a madman trying to get a body count in a gun-free zone. So naturally, we're going to make it easier on them here in New York State. What the judge said is the blanket ban is gone, but you may not carry in a church except for those, this is a direct quote now, for those persons who have been tasked with the duty to keep the peace at the place of worship or religious observation. So Effectively, what that means is up to what your lawyer can articulate. If you're part of a church safety team, you're clearly covered by this. But if your church leadership allows for concealed carry because they believe that having more good guys with firearms is a good thing, you'd probably be covered by this as well. But again, that's where it's a function for how lawyers can hash this out in court. But the blanket ban, that's gone. So it's a major victory on balance for gun owners, but it's still an insult to us in so many different ways that runs totally contrary to the Second Amendment, to common sense, to Bruin, to all of it. So the question now is what's going to happen next? Again, many lawsuits were filed. The federal judge interacted with at least one of those, and he has blocked the enforcement of all the provisions I mentioned a minute ago. Tish James has responded to that and asked a higher court to weigh in and give their answer on this. And that's where NYSFA is fighting with our amicus briefs. We're digging in right here to make sure we can smack down all the bullshit that's being passed around as established law by Tish James on behalf of Kathy Hochul. So the timing on this is not known. It could happen very quickly. I wouldn't be surprised if it does. But the real question you're asking is, for heaven's sakes, can Supreme Court justices weigh in on this again? Can we get relief at the Supreme Court level? And guys, nobody can give you a direct roadmap on this, and we're not going to try in this video here. But here's what I can say. Clarence Thomas, clearly, if you read the Bruin decision, went out of his way to look down the road in the future and see every little tyrant like Gavin Newsom in California and like Kathy Hochul here in New York. And he wrote the decision knowing they would try to violate it. And that's why he said any future gun control laws need to be in compliance with Bruin and show how that law complies with the natural history of the American people carrying firearms across this country. This does not pass that standard by any stretch. What you saw here now from Hochul and all the little demented tyrants in the legislature here in Albany was a middle finger raised to Clarence Thomas and to President Trump and all the conservatives on that bench. And I would not be surprised to see them grant an expedited status to receive this case into their chamber to weigh in on this. We cannot wait 5 years on this. The implications of Hochul's law being sustained, the implication of saying that no gun owner in New York State can carry in any retail business unless that business has a sign that authorizes concealed carry, it's going to make felons out of countless New Yorkers. So there is an urgency here. SCOTUS, I believe, will be keenly aware of that, but we can't get there until we first get past the Second Court of Appeals. Guys, that's where the fight is right now. That's where we're fighting. For all of our members and supporters, thank you so much for all of your donations to help fund our legal battle against this demented tyrant. Guys, if you haven't made a donation, help us out right now. We can't wait. We can't wait 5 years for SCOTUS. We can't wait for national groups to come in here and try to help us. And we can't hope for the best. We can't overturn this insanity here in Albany. The only option for us right now is the federal court process. We are engaged in that because, folks, we live here just like you, and we cannot afford, any of us, to wait and see what happens. We have to fight in federal court right now, guys. Stand with us. Join the fight. Donate today to our legal battle, and we'll keep you guys informed. Take care.